Доброго дня усім, хто зібрався у залі.
Good afternoon to everybody of those present. And we would like to announce this briefing on the Public Integrity Council's position regarding qualification assessment of judges. We have Mr. Kazakov, who is the member of the Supreme Council of Justice, Mr. Shotka, who is the secretary of the Secretary of the Commission on the Qualification of Judges, herewith we announce the beginning of our briefing. Good afternoon, everybody. Since yesterday, we've witnessed a number of developments in what we call the information space, bluntly speaking, in the Ukrainian media, and we decided that we cannot oversee these developments. We need to react. The Qualification Commission has been working in its present composition for the last 3 years. There are 10 judges, members, practicing judges, and 6 judges who are retired, a number of academics. Our main function is to select the judges for their positions, future positions in the courts of justice, their training, and also participation in the contests, procedures through which the judges are selected when, for example, a judge decides to move horizontally, so to say, from a one-level court to the Court of Appeals, the Appellate Court, and so on and so forth. So we have gathered today in order to inform you on some results of our work and also to inform you about some facts so that you can understand the topic of our today's discussion. In 2016, our commission started working in this area of qualification assessment of judges. The goal was to fulfill the law on the right to the fair trial. It was for the first time that two instruments were used, like, for example, the broadcasting of a job interview, and also the communication, our communication with the judges, future judges or acting judges, not acting, but the working judges, sitting judges, who with the considerations provided by the documents from the National Anti-Corruption Bureau. As of now, more than 1,500 judges have left the judiciary system of Ukraine, and so we consider it to be somehow a result of our work. Also because in a number of cases, the qualification assessment was a direct reason for some of the judges to leave the judiciary system. So in the first years, there was another procedure introduced, the disciplinary action, when, for example, in the first instance, courts, about 90% of the judges were assessed. And we have the figures on how many of the judges were sanctioned from the disciplinary standpoint, how much disciplinary actions have been taken by our commission, our composition of commission, and the previous one. This certainly is not something to celebrate. This is a rather sad information, but we wanted to share it with you. Yet in the autumn, we started a procedure on the selection of judges to the Supreme Court of Ukraine. Also, our commission took part in the selection of the candidates for the positions of future judges. More than 4,120 candidates were assessed. 400 of them were selected. As of now, about 300 remain. And those around approximately 300 people, they started trainings at a school for the judges, having finished which they can they can fill in the vacancies of the judges within the Ukraine's judiciary system. That's what we call the renewal, or rather the renovation, of the judiciary of Ukraine. In total, around 2,000 positions are not filled now in the judiciary branch of Ukraine, and the situation is quite close to critical. Especially if we bear in mind that the judges can also fall ill or go on vacations, and therefore these courts that were left without the judges entirely, they simply stopped functioning. Good afternoon, everybody. Good afternoon, the members of the press, the members of the public. I'm pleased to see you here in this hall. Our colleague's recent statement was quite unexpected for us, and I feel it my duty to also state that your support will be very essential for us. And let me now describe a little bit more in detail the primary, so to say, procedure of the selection and assessment of the judges. The judges are being assessed on their corresponding to they're being qualified enough for the position of a judge. This procedure is used as an extraordinary procedure sometimes, but if it is launched and if a judge has not passed this procedure, or he or she refused to go through that procedure, he or she is just dismissed. The Supreme Council of Justice of Ukraine has commented on that procedure and on the need to apply this procedure to all the judges throughout all of Ukraine, and basing on the conclusions of the Venice Commission and some other legislative acts and norms that are in effect in other European countries. The assessment of the judges does not invoke necessarily their dismissal. And when we were made aware of that fact, that was brought to our attention by the Venice Commission, we said that in Ukraine there was an absolute lack of trust into the judiciary system. The Venice Commission then recommended that these procedures, that the procedure we use for the assessment of judges be within a strict time framework, would be transparent, and so on. But as our legislation ties this assessment procedure to the emolument that the judges are supposed to get after they fill in their vacancies in the courts of law, it brought about the situation when we are lacking, as was said, a couple of thousand of judges out of if I'm not mistaken, 8,800 judges that are needed and whose positions exist now in this system of the courts of this country. This is all to say that the judiciary system in Ukraine functions under great strain today. And so these issues, as you understand, are quite pressing. And in October of last year, this assessment procedure became a subject of discussion. And as it was launched, as we have already told you, a couple of thousand of candidates were assessed. And if I'm not mistaken, everybody was informed about that procedure. Both the public at large and the Public Integrity Council was aware of that position. Because we have been working on on various materials for the tests that the judges were supposed to pass, and so on and so forth. Also, certain procedures were developed to assess the ethical and anti-corruption sides of the candidates, and the Supreme Council of Justice and the courts themselves, they supply information to us before the interviews with the judges, and the tests that were started in February of this year, if I'm not mistaken, on February the 14th, within a month, by March the 15th, the first 1,000 of judges or candidate judges were assessed. So our colleagues said that within a very brief time our assessment procedures are, or rather the interviews are, take very, very short time. We are going to certainly take that into account, but certainly not in the cases when the interviews have already been done. But the interviews themselves are done in a manner in which the members of the Commission, Qualification Assessment Commission, they are well prepared for these interviews. Therefore, they do not require much time. So, if we see that someone has an impeccable professional reputation and nice, good indicators, strong professional indicators and results of his work, it's understandable that the Qualification Assessment Commission can review this candidacy quite quickly. Here I brought you a file of one candidate, and just to show you what the average size of a file for each candidate is. Again, we take into account a number of indicators, a number of parameters that are by the members of our commission. They are taken into account, like ethical abidance by the ethical norms, abidance by professional standards, but also we try to assess some factors that are not directly related to them, performing their functions within the court premises. Some people call that manipulative, parameters and so on. But we sought to make those judges assessed as qualified that the Commission, against whom the Commission didn't have any objections. For example, if there were any disciplinary actions started against some of the candidates, and I need to inform you that according to Article 184, Part 5 of the law of Ukraine on the status of judges, the review of these candidacies was stopped, not only postponed, but just stopped whatsoever. And upon the agreement with the Supreme Council of Justice, we applied the procedures, assessment procedures, as I have described, in their entirety. And again, let me stress it again that while assessing a candidacy of a judge, it is important for our Commission to be entirely secure to have the proofs of its decisions. And so this procedure is not a contest when you need to find the best one. It's the qualification assessment procedure. And in doing that, the Commission needs to check how a person can continue working in the position of a judge, or whether a person is qualified for a position of a judge. Therefore, we want the documents that are divulged, so to say, by our partner organization, the Public Integrity Council, that they be also objective, and if the decisions of the High Qualification Assessment Commission of the judges, if it makes its decision, that these decisions are not objected to, or there are no attempts to reverse these decisions or annul them. Speaking about our further work as we see it, we are going to turn to all the sources that we might need for our work. If we speak about disciplinary actions, then the appropriate sources that can give us this information, if it's even criminal procedure initiated against a judge, then there will be the bodies of criminal justice with whom we are going to cooperate. There have been the examples of both in both areas. Well, before we start questions and answers part, I would also like to make just a few observations as the events of last Friday have been referred to, that, for example, the interviews took 6 or 7 minutes on Friday with some judges. Let me emphasize that, and I refer here only to to what I witnessed myself. A number of colleagues, members of the Commission, only finished their working hours at 8 o'clock in the evening. So they worked until that late. And you should bear in mind that during these interviews, some discussions and some interviews are, become a scene of very heated discussions and debates. Now let me invite you to questions and answers. Channel 24, Anna Kaluzhna. First, we cannot have any understanding of that meeting of last Friday because it was not broadcast and no materials have been published. And this is unusual because before the previous meetings of the sittings of the Commission, they had their results had been published, and the materials on them had been published. And then another question is, what do you mean by saying that the conclusions or the opinions of the Public Integrity Council should be presented differently? What should this different form of presentation be, in your opinion? Because let me remind you that the government calls all that is happening now in the judiciary system of Ukraine a judiciary reform. The cleansing of the judiciary of the corruption and so on and so forth. Well, let me first start answering. Well, getting back to the question of broadcast. The law says that during the interview and the assessment procedure, any of the interesting parties can take part. And I know that, for example, some of the procedures, well, some of the sittings of the committees had around 7,000 views on YouTube. So you can understand that the interest is quite high, and we can certainly invite some people to the sitting of the Commission, but not 7,000, understandably. It's impossible. And therefore, that time, last Friday, there was a technical problem with broadcasting 4 streams at a time. And our IT specialists are now working on resolving that problem. And these things happen, you know. There was, for example, the Supreme Court meeting which was to be broadcast, but the sound was disappearing from time to time, so on and so forth. And the second question. Well, the second question is probably more addressed to Mr. Stanislav. He mentioned that the conclusions and the opinions of the Public Integrity Council should be somehow differently formed and presented in a different way, in a different manner. My question regarded that different form. What could it be? Well, I read in some of the statements of the Public Council that they were somehow squeezed by us from this procedural space, so to say. But let me say that for the judiciary to enjoy any trust of the public should be aware and preferably see that the justice is being done. And so if you visit a Facebook page of the Public Integrity Council, you could see that there was a heading informing that the members of the Public Integrity Council were conducting their meeting or sitting or meeting. And at one of the recent meetings of the Supreme Court, we also informed the justices of the court to present their conclusions, also attested, so to say, countersigned by the members of the Public Integrity Council, so that we can see who were the members of the meeting. It's the same with our commission meeting. In this procedure, the stakes are quite high. A judge may be dismissed from his post, and we just asked the Public Council to give us the documents that would also be formally, so to say, valid. The minutes, for example, of the meetings with the list of the participants of the meeting and so forth. Usually in the minutes they write that this person, for example, left the place of the meeting, the premises, then returned to the premises, and so on and so forth. Last time, what we received from them was a couple of lines saying that the conclusions were voted for by 14 members. No, not a single name there. So we couldn't even understand who took part in the voting. Let me ask the organizers to help us in restoring our right to present our point of view freely. So, not to mention the fact that there were no conclusions added to the minutes, and we think that, speaking from the point of view of transparency, it's it's a little bit dubious. The accusations were sounded that we threw some conclusions or something out. That was simply not true. We asked our colleagues to make the to review the documents as they presented to us, and to make the corrections, to add rather the things that we asked them to include in those documents, and but they have not yet done it. Again, let me emphasize that we are open to critique. We are ready to take into consideration any observations, and any comments and opinions. I cannot hear the lady, the interpreter cannot hear the lady, she speaks without a microphone. I cannot hear the question. Let me explain. The qualification assessment, as I have already told you, is to check whether a judge corresponds to his or her position. According to professional ethics, to the ethical standards of his or her work. So now a candidate is supposed to score 1,000 points, and the threshold for passing this assessment, qualification assessment, is 67%. So if his competency, his professional competency, and his ethical standards, adherence to these ethical standards, and so on and so forth, bring or reach 67%, then he or she is considered to have passed that assessment. As far as this accusation of that all the judges are subjected to that assessment procedure, let me say that there have been a number of people, more than 90 people, who left their jobs voluntarily by their own decision. But as of now, of those people who haven't passed the test and haven't done their practical tasks that they needed to do in writing, 24 people didn't pass these, didn't do these tasks. So out of more than 600 people, according to my calculations, it's something like 3.2 percentage points out of the total number of the judges. So 656 judges in total were under assessment, and 24 people were assessed negatively. But in our view, this is just the evidence that this is the process of, so to say, sanation. We are making the judiciary system of Ukraine more healthy, more transparent. So those judges who had themselves the doubts about their professional or ethical standards, they had even a chance to leave themselves. But those who agreed to this assessment procedure, they are now being assessed. And let me tell you that every week I and my colleagues and I in the Commission, we review around 60 written tests, written tasks as we call them, that the judges need to complete in order to pass this qualification assessment procedure. So let us exert our efforts and stay on the point of view that those who want to work and to pass this qualification assessment, they have the chance to do that. Those who are unwilling to do that, we do not force them. I'm reviewing now the statement of the Public Council. With regard to the judges who have already been dismissed, do you react to any objections by that Public Council that, for example, the Maidan judges, many of them remain in their positions? Let me explain it to you by referring to the decisions and conclusions and opinions of the European Council of Judges that states that the judges should only be judged by their decisions, and no body, administrative or political or governmental, can judge or assess a judge on his decisions. Only the judicial bodies can review these decisions from the standpoint of the law that was supposed to be applied in that judiciary, in that decision of the judiciary of the court. So we do not refuse to take into consideration disciplinary shortcomings that a judge might have committed. But in terms of the professional decisions by the judges, they can only, their professional decisions could only be, their judgments could only be reviewed by the other courts or the bodies of the judiciary. For example, if somebody wanted to object to a court's decision, the only reason that we might not react to that was that the term of the claim on that that decision has just expired. But it seems to me that the decisions that were made against the Maidan participants, the courts made those decisions and you do not take them into account, I think it's something very much out of order. Well, let me give you an exact figure. Because previously I gave some figures that might not have been absolutely correct. The Commission has been functioning since 2010. That was the very beginning of its work. In the 2014, for example, there were 5 judges. But with our new composition of the Commission, 318 judges were subjected to disciplinary actions against after the qualification assessment. Last year, 46, and with the amount of judges I mentioned that were disciplined in 2013, it's the total amount reaches about 500 judges, and more than 500 judges. And by the way, why only things related to Maidan? Because there have been much more severe things, like, for example, the hostile takeovers done violently with the participation of armed gangs. For example, very recently, around 40 people came from former Dnipropetrovsk, later renamed in Dnipro. It's a big town of 1 million people. So from Dnipropetrovsk Oblast, the administrative region of Dnipropetrovsk, more than 40 people came, farmers mostly, saying about their lands being practically misappropriated by the new owners illegally and practically violently. These are the things that we need to review too, and this is also the subject of our work, or object of our work. Well, speaking about public integrity, wouldn't you agree that disciplinary actions are sometimes not a valid response to some of the wrongdoings committed by the judges? Well, we have already accumulated, so to say, a lot of experience on how to best gather the information, collate the information that we need in order to establish whether a judge's integrity has been jeopardized or breached or not. And let me say that among, so to say, classical standards that we use when we prepare ourselves as the members of the Commission to assess a judge, we send out different requests to different government bodies, including law enforcement agencies, Anti-Corruption Bureau, for example, the tax returns. We also examine them, and we review all the disciplinary measures, disciplinary aspects, any claims against the judge, any complaints against the judge. So we use all, so to say, every open source available. And let me tell you that long before the Public Integrity Council existed, we had been working and assessing the qualifications of the judges with all these aspects duly reviewed, duly taken into account. All the same, after the Public Integrity Council was formed, we started cooperating with them, and we consider this cooperation positive. but it was on many occasions much easier for them, as the members of the non-governmental organization, to get information that we could not get formally, so to say, in an official way. Therefore, the materials that the Public Council has, I hope that they share with us all that information, and we appreciate that information, even if it's not a properly written conclusion and properly done from the legal point of view, a conclusion. We still appreciate the information that they can share with us. Zakony and Business magazine. What is your Commission's opinion about the reason of the Public Integrity Council issued that statement? Wasn't it the large the large number of judges that are now being assessed? Because they are an NGO, and they might not be simply able to match, so to say, the speed of your work and the scope of your work. Well, I think that that's probably the easiest answer. And let me greet Ms. Chejik, whose birthday it is today. Let me also share with you an opinion of a well-known Ukrainian poet of the 19th century. Oh, rather, it's this is the opinion posted by someone who uses the avatar of Taras Shevchenko. The Public Integrity Council decided to leave this procedure of qualification assessment of the judges, and we think that having obtained a certain authority, the Public Integrity Council shouldn't abandon them, and because they have almost become a part of the judiciary system of Ukraine, or law enforcement system of Ukraine. Thinking strategically, we think that each the opportunity to, so to say, to filter the indecent charges it should be used. If a Public Integrity Council can influence the situation with corruption in the judiciary system of Ukraine better, then they should try and do it. So this model, when the judges only decide who can and who cannot be a judge in Ukraine, this system or this model is not valid. It cannot produce fair and transparent judiciary system in this country. And the Public Integrity Council is now somewhat indeterminate status. It's not an NGO any longer with its authorities, but it's not yet a governmental body. So the NGOs that make part of the Public Council, they can have some authority in forming the governing bodies of the Public Council, but they have no say in determining the Council's decision. we can compare this situation with a member of an electoral committee inability to refuse a voting bulletin to any voter. Similarly, the Public Council cannot just take part or withdraw itself from the qualification assessment procedure. I do not agree with everything that was said in that post, but still it has a lot of valid ideas and opinions. So, for example, when a bill was written on the qualification assessment, and when a Public Integrity Council was included in there, probably those who were putting together that law, they couldn't imagine what amount of work both the Supreme Qualification Assessment Commission will have to do, and the Public Council. And when it was mentioned that, for example, some of our colleagues worked last Friday until 8 p.m., sometimes it's even much longer. We sometimes confront the situation when the Public Council publicizes the information about high salaries that the judges have and we have as the members of the Commission, but they are reluctant to mention the amount of work we do. So these things, that they have mentioned in the statement, they were not quite substantiated, as well as the whole effort of qualification assessment. We might say it now with a great deal of confidence that not all aspects certainly have been, according to the best, have been ideal. So my question is whether you are going to continue working without cooperating with this Public Council, or what's the future? Because they seem to have all left their positions in the Public Integrity Council. Well, I cannot comment yet on their decision, because I left, for example, I started working today at 8 a.m. And I simply do not have information. Well, let me ask you about the format of the document. Why do you need the signatures of our members of the Public Council? We, for example, also forwarded even to the Supreme Court of Ukraine similar documents with no signatures, and then can you refer to any specific law or article in any law that gives you the authority of determining the format of the documents that we, as the non-governmental organization, are supposed to submit the documents to present the documents to you? Well, here on this slide you can see the minutes of the electronic voting on the decision on a decision of the Public Integrity Council of March the 11th, and it only says that in one line that the voting was affirmative, 10 votes out of 17. you should pay attention to the fact that it does not even mention even who, with regard to whom, what judge was that decision taken. In our work, we state all the judges who make a certain decision or who object to that decision. The signatures can be made either by hand or you can use an electronic signatures. For example, you can see here the format of a document that is done by the court. It's written the head of the court, then the members of our commission. Sorry, not the court. The presiding person or the chairman, then the members of the commission, their names and their signatures. Well, I suggest leaving this format of of a discussion, of a debate here in this hall, because we are supposed to have a briefing for you. Well, let me add a few words. You are appealing to our views on the procedures. If we visit your website, we can see there a reflection, so to say, of your work. In this case, in the case of these minutes, I cannot even see whether how many, who were the people who voted, what were the objections, and so on. And you have become a part of the legal process of the judiciary, functioning of the judiciary system of Ukraine. And the stake here is a career of a judge. For example, a judge can be dismissed upon that decision. So that's why we pay due attention to, proper attention to formatting our decisions with signatures and so on and so forth. Why don't or can't you do that? Can we again turn to the organizers of this briefing, asking for our constitutional right to share our opinions and views? Well, I do not object to your constitutional right. Please refer us to an article in a law with which you can establish the work of our Public Integrity Council. Well, let me repeat it again, that we do not establish, and we have not established, and we are not going to establish anything that is not constructive, that is not that does not contribute to the efficiency of the judiciary system. It seems to me that if we abide by the norms and rules that are effective in the judiciary system, we would be more convincing. We would really look like a government body whose decision was substantiated, grounded. There is a law on the judiciary system of Ukraine. If you need an exact name of the act upon which we base our requirements. Well, let me also tell you that this issue under review now in the court of law. We know that a colleague of yours has turned to the court, and we are ready to provide our opinion, and we are going to provide our opinion. So we'll have an opportunity to debate that in the court. Well, my question regards the future of this qualification assessment process. Does the fact that the Public Council left that process, does it reduces, so to say, the legitimacy of the qualification assessment? And how can you comment on their objection to the fact that the Qualification Assessment Commission itself changed its rules of procedure so that the Public Integrity Council's work is practically brought to, out of that process? Well, the term of delegitimizing that you have used seems to be absolutely out of place to me, because we are going to continue to work constructively. We are of the opinion that it's not the manifestation that is the best format of discuss or demonstration that is the best for the discussion of the work and functioning of the judiciary branch. And let me give you an example that there was a member, certain Mr. Maslov, who was a member of the Public Integrity Council, who had some disputes with the journalists, but in as far as his cooperation with us, it was his work was impeccable, and it was the work in which scheduling was very important, because dozens of judges were visiting us, and we had to discuss lots of things with them in the course of the work of our commission. But that work was done in a very well organized manner. The last question, please, because we are running out of time. When the members of the Nebesna Sotnya met the members of Nebesna Sotnya families, there was a question mentioned about the illegal or illicit enrichment of a member of the Qualification Assessment Commission, Ms. Wislitska, I think. Ms. Weselska, sorry. There has been her tax return was not filled in properly. There were some shortcomings found there. How could you say that she can assess the qualification of the other judges if she herself is now an object of the review of her tax return? Well, it's not our competence to make any decisions on her work. It's the higher judiciary authorities that are entitled to make to assess her work. but we have not yet seen so far any dubious aspects in Ms. Weselska's work. Well, let me again stress that if there is a criminal procedure against someone, like, for example, a fact was committed, or a wrongdoing or a crime indeed is a proven fact, or rather a fact that has already been committed. According to my information, between 500 and 600 cases, between 500 and 600 cases, close to 600 now, when different law enforcement agencies initiated criminal proceedings against the judiciary decisions, the decisions of the courts. 3 of these so far of these criminal proceedings are now reviewed by the courts, but a lot of people say that such a criminal proceeding could be an instrument of pressure on a justice or on a judge of any court. So, as again with Ms. Weselska, let us wait and see what are the results of that review of her tax return, and then make any conclusions. Let me call on you as referring to a well-known movie. Let us go along. Let us be friends. We suggested that a simple thing be done with regard to the formatting of your documents, and we can go on cooperating. If not, then. Well, what's still the question is what's about the future? Are you going to cooperate or trying to go? To cooperate with the Public Integrity Council, and are you able to continue working without Public Integrity Council? The Public Integrity Council, composed of 17 members, it remains. It's not that they have all stopped or refused to continue working. They remain. The Public Integrity Council remains. They just distance themselves from this procedure of qualification assessment. If there is a contest, for example, for the members of the Specialized Court on Intellectual Property Rights, there will be, they most probably would participate. Well, you said that they distance themselves. What does that mean? You probably should ask them. What does it mean for you? We are going to continue working. Our functions are set by law, and we are going to continue working according to the law. So it's not going to affect your decisions. We are going to make our decisions as we are supposed to by law. We are going to conclude our meeting. Thank you.